Good evening. This is Rahul Reddy live here from Houston, Texas. Reddy Neumann PC brings in immigration updates every week on Tuesday at 5 p.m. Central Time. Along with me is my business partner, Reddy Neumann. Emily, now with all the pandemic going on, Trump administration is changing its policies every week and sometimes even every day. In each of the policies, some of the immigration policies, they're changing every week. What do you have today to discuss?
Yeah, so one of the common questions we've been getting through our consultations is what options do you have in the event that your extension gets denied? So
is it extension or transfer, transfer of H-1B gets denied also, is that right, Emily?
Correct.
So what options do I have? My I-94 has expired and I got my H-1B extension denied. What do I do?
So the first thing to understand is that because the I-94 has already expired, while the extension was pending, you were not necessarily in your H-1B or L-1 status. You were in what's called a period of authorized stay. The denial of the extension ends that period of authorized stay, and from the following date, the day after the denial, unlawful presence accrues. And we've talked before about the 180-day rule, where you need to make sure that you do not have 180 days or more of unlawful presence, because that triggers the 3-year bar. So that's the most important thing to keep in mind. Whatever you're going to do, you need to make sure that you have either your status back in place or you exit the country before day 180. Now, what can you do to get your status back in place? Obviously, this depends on the reason for the denial, but if it's something that maybe with more documentation, maybe with a tweak to a job description, different SOC code, something like that, you can overcome that denial. One good option, especially when premium processing is available, is to refile the extension. Obviously, it's going to be a late filed extension because your I-94 is already expired. That's where you make a nunc-pro-tunc argument. That's where you're asking USCIS, in their discretion, to overlook the gap in your status and put you back in status due to the extraordinary circumstance, which is the denial, and because you and your employer quickly work together to get that refiled and overcome the grounds of denial. I do recommend doing that in premium processing because, again, you want to get the answer before you hit 180 days. We've had a lot of good success with that when we get the approval. Most of the time it comes with the new I-94, putting the person back in status as if they never fell out of status. Appeal is an option that you always have after a denial, but you have to be aware that the appeal does not stop the accrual of unlawful presence. So the entire time the appeal is pending, your 180-day clock keeps ticking. Now, if the appeal is ultimately successful, then they put you back in status and approve your petition as if the denial never happened. But that's a big risk to take because you don't know if it's going to be successful. And the processing time of the appeal might be, very well should be, more than 180 days. They're not fast. So you may wait 180 days and ultimately get your appeal denied. You've been unlawfully present that whole time. And the appeal also does not provide you with work authorization. So for that reason, refiling often is a much better choice when premium processing is available, so that you can get your status taken care of before the 180-day mark hits.
So Emily, this is the same rule that's applicable when it's a change of employer too. So in situations where the extension has been denied or the change of employer has been denied, do you suggest going with the same employer, or can a new employer also file under the non-pro-tunc argument and file a H-1B?
I don't think there's any restriction one way or another. It all depends on what argument you're trying to make. So typically, in my cases, will usually refile with the same employer because I want to show that my employer should have been approved the first time around and that the denial was actually an error. So my argument is stronger in making that when it's the same employer. If it's a different employer, now your argument is different. You can't argue that the denial happened in error because you're not able to really overcome the denial. You're just trying again with a different employer. So in my mind, if I feel like the denial was wrong, I prefer to file with the same employer.
Emily, on the right now with the furlough, we do see that, at least the IT jobs are doing good, but of course, different sectors have different things. We're seeing a lot of people who are getting out of the job. What would they do if their I-94 is valid, especially on H1 and also on L1? What if their I-94 is not valid? What do they do at this point of time if they get out of job?
Yeah, so that's an important point, is whether the I-94 is valid or not, because in order for the 60-day grace period to apply, your I-94 has to be valid for at least 60 days. So in that situation, if you can find a new employer and file a transfer or file a change of status to some other type of visa category within the 60-day period, then it's treated as if you were in status the entire time. So that's kind of your best case scenario. If the I-94 has already expired, then you're looking at finding a new employer or filing a change of status, making that same nunc-pro-tunc request, explaining that the delay in filing or the late filing was due to the extraordinary circumstance of the job loss and bad timing around the I-94 expiration, and basically asking USCIS to use their discretion to put you back in status. We've had relatively good success in those kind of requests during the COVID-19 pandemic situation. For the most part, USCIS has been somewhat forgiving. I wouldn't say rely on them always being this forgiving, but lately they have been a little more flexible with allowing those nunc-pro-tunc arguments.
Emily, you told previously to the audiences of the YouTube and Facebook that there should be a furlough of the USCIS on August 3rd. Is that true, or is there any changes, or what's going on this furlough issue?
Yeah, so somehow information got out to the Senate that actually USCIS is not having budget issues right now, and they're going to end this fiscal year, which is September 30th, with this budget surplus. And so several members of the Senate were pretty upset about why they're planning to furlough U.S. workers, 13,000 of them, when they have the money to keep them employed. So USCIS backtracked on it and said, now we're going to delay the furlough to at least August 31st while they figure out next year's budget issues. So there's still going to be a budget fight. Tomorrow there's a hearing on holding USCIS accountable for their budget issues and the policies they put in place that have caused these budget issues.
Who is conducting the hearing?
The House, I believe.
Yeah.
So that should be interesting to see what kind of
results will come in.
Yeah.
Hopefully so. Trump administration has right now has said that they are going to reject any new DACA applications that have been filed right now. Any comment on that, Emily?
I think it's not unexpected. We've known quite a while that the DACA deferred action for childhood arrivals, those are the dreamers, that the Trump administration has been wanting to eliminate that program from the beginning, and they actually tried to eliminate it, and the Supreme Court said, no, you haven't gone through the proper process. Now, everyone thought, including the Supreme Court, because they ordered it, that everything was going to go back to how DACA was before the Trump administration came in, and not only would they have to accept renewals, but also new applications. That's what everyone was waiting for over these last 5 weeks. Then all of a sudden the Trump administration comes out today and says, we're not going to accept any new applications. On top of that, renewals we're only going to issue for 1-year increments, because we're still planning on eliminating this, and we don't want to give anybody any reliance interest in this, that they've been extended for a long period of time and now we can't eliminate the program. So that just goes to show that the Trump administration is still very anti-immigrant. All of his talk a couple of weeks ago about some executive order bill, merit-based, and it's going to be great for DACA, obviously is not what really is going to happen.
Executive order was being passed in June of 2020. In the executive order, the Trump administration has banned H-1Bs, L-1s, and J-1 visa people, and to the H-2B visa people to enter into the United States, especially those people who don't have the visa status. Those people who are going for stamping, they couldn't enter according to the executive order. Then there comes a change in the executive order where they said that if the primary beneficiary, that means in the case of H1, it's H1B, L1 or L1B visa person, and if the dependent is outside the country, they could obtain the H4 and L2s respectively. Now, there is another twist to it. What is this?
Yeah, so, we all talked about when the order first came out, it said specifically that this applies to people who are outside the U.S. on June 24th. So we all thought, okay, if I'm inside the U.S., the order doesn't apply to me and I should be able to later go and get my visa. And the Department of State seemed to disagree with that. So there was a lot of Twitter back and forth of people asking for guidance, asking specific questions. Why are these people not able to get their visa if they were in the U.S. on June 24th, when the plain language of the order says it only applies to people who are outside the U.S. on that date? So after quite a bit of backtracking, now they're stating that if you are currently in the U.S. and your visa has expired or is going to expire, and you're in either H-1B or L-1A or L-1B status, you are still eligible to get your visa before December 31st, assuming the consulates reopen to routine visa services. So they've again narrowed who this applies to. It's not as broad as originally planned. So it sounds like if you're currently in the U.S. or you were in the U.S. on June 24th and then left, but you have a valid approval notice for H or L status, you should be able to get your visa. I think now that leaves us, one of the big questions is, what about people who were in the U.S. on that date but in a different status? The most common situation is people who are in F1 status and applied for a change of status to H1 in the lottery this year. Their cap subject H1B hopefully will be approved and kicks in on October 1st. Those people were in the U.S. on June 24th, are currently in the U.S. maintaining status, but we don't have clear-cut guidance on whether those people will be eligible to get the visa stamp before December 31st or not.
Yeah, Emily, let's go to Q&As with regards. If anybody has any questions, guys, you can post it on the YouTube and Facebook. We will try to get as much as possible. Question came from the audience in the Facebook is that if I'm not working for a company, can they still file the labor certification? Since the green card application is for the future employment, can I join later on? How much I can delay joining that company? The rule says that you should join definitely after you get the green card, which may be for, according to the law, it's a lot of years for Indian nationals. So there is no, technically you don't have to be working for the company at the time when you file the application. It's only required that there must be a promise of employment and you must be willing to join after you get the green card. Now, having said that, Emily, there is some other news floating around. As last week we said that the USCIS might allow all the people to file the adjustment of status whose I-140 has been approved, might allow. Now, the State Department has released that there are 110,000 extra green cards that are going to be given for the employment-based green cards next year. So, employment-based already has 140,000 green cards, plus this 110,000 green cards, you're speaking about 250,000 green cards. Specifically, I'm expecting, because there is not much backlog with the other countries, this 110,000 green cards, most of them, if not all of them, might go to Indian nationals. Mm-hmm. Is there a chance that the priority date might move very fast, especially for EB2 and EB1 and also EB3 also?
I do think it should. What the problem is, we don't really have any insight into how the State Department moves these dates. And they tend now to move them. They have targets in mind of how many green cards they need to issue each month to be able to use up all of them by the end of the year without using them up before the end of the year. And so if they're going to go by just those targets and move the date incrementally, then we might see movement, but slower movement. At the same time, because they don't want to have to go back and forth with the dates. If they push them too far forward and take too many applications where they can't process them fast enough, or they run out of green cards before the end of the fiscal year, then they're going to have to retrogress everything again. That was the whole reason they created this dates for filing chart, is so that the final action date could move systematically based on their monthly target numbers that they want to hit, and they can push the filing date forward further to allow USCIS to accept applications earlier so that they actually have enough time to process them all. Because right now processing times are like a year. They might not even get to all of these applications.
What do you mean processing time is?
For the 485, it's more than a year.
It's 2 years.
Yeah. So that's the difficulty is, yes, the dates might move forward, but will USCIS actually be able to process all of them even within the fiscal year? That remains to be seen.
We definitely do anticipate the priority dates to be moved, and we are going to get a lot of questions on, can it come to this date, can it come to that date? We have gone wrong many times. Please don't ask the question. You can see the priority dates movement every month, somewhere between 9th and 20th. You'll get the priority date and you can look into it. That would be the easiest way, rather than asking us, will my date be current? So please avoid that question for us.
Reshma from Facebook has a very hot topic question right now, is what's going on with biometrics? H4 EADs are being delayed so much because we can't get the biometrics appointment notice. What options do we have? People are losing their jobs. We agree this is a horrible situation. We've been filing lawsuits on that exact issue until the biometrics issue came up, to where they weren't processing them because the application support centers were closed. Now they have been reopening those. We have been getting slowly new biometrics appointment notices for pending I-539 applicants, but we also, have done a couple of service requests to try to get things moving. And in response to that, at some point, some of the customer service officers are saying it may take us 60 days or more to get through the backlog, which is ridiculous. And some people were even told, oh, don't follow up again until October for their biometrics appointments. So that is definitely problematic. We are hoping to be able to resume our H4 EAD litigation soon. We've got 2 cases that the outcome of those will determine where we can go from here. But that's really the best option, because we're not getting anywhere with congressional inquiries. We're not getting anywhere with service requests. The Ombudsman office is not really doing anything about it. Litigation seems to be the only thing that works, but our hands are tied on that at the moment.
Srivardhan has this question. His Vermont Service Center, they have filed premier processing. In July 25th, he has not received the receipt notice. What is the next step to be taken? Just have patience. Just wait for 1 more week. You will get the receipt notice. It typically takes anywhere between 2 days to about 10 days to get a receipt notice. So you should not be panicked. Now, here is what I want your attention, Emily. Farheen has this question from Facebook that he's Farheen has this question that sorry, give me 1 second. What Farheen has. Any update on the consulates from Canada? The last time that I got an update from the consulates of Canada was actually they were able to get an appointment in October. The appointments that were being done in July were being canceled. Do you have any more updates on that?
I don't have any updates beyond that, other than everyone wants to know when all of the consulates are going to be reopening, and all the Department of State is doing is telling people to visit the individual consulate's website. It's going to vary based on what's going on at the local office at any given time with their COVID-19 situation. So, all you can really do is make sure your DS-160 is submitted and complete, and just keep checking that website for when appointments become available, and grab the first possible one that you can, because they disappear quickly. There's no rhyme or reason to which consulates are opening when and when appointments are available. It's all based on the individual consulate and what's going on with the virus situation at that point, which makes it really difficult for people to plan and try to get on with their lives, and we definitely understand that. But we're kind of at the mercy of the virus right now.
Can I apply emergency H-4 visa for my dependents if the primary applicant is in USA? You can try to see if they will take the appointments, but sometimes they may not entertain you in getting the they may not entertain you in getting the emergency appointments though. So that's the reason why emergency appointments, sometimes they're entertaining, sometimes they're not entertaining. You must have a very valid reason for you to get the emergency appointment. That you're separated from your daughter, that's not enough. Separated from the wife, that's not enough. There must be some other compelling reasons like medical or something like that. Those are the only things that we have noticed that are allowing for the emergency appointments in the consulate though. What is the current Pavan is asking the question, what's the current time for the H4 and H4 EAD processing time in Nebraska Service Center? The processing time is anywhere between 8 months to 18 months. 8 months to 18 months to get the H4 plus EAD approved right now in Nebraska Service Center. 1 second. Question that comes is that I have two parents who are visiting, and one of should we file parents separately for the I-539 application, or should we join them together and file the paper application? This is a great judgment call. When you file online, you can only file online application. You can only file one person though. When you file a paper application, you will be filing. You can file two applications. In that way, you can save some money. However, I do not recommend that you file a paper application. The reason why I tell you not to, I recommend you not to file the paper application is because there are a lot of discrepancies that goes in the paper application. If the application is not received properly, one click box is clicked wrongly, the entire 2 people will be thrown out. Even though it costs a little bit extra, we normally recommend that you file an application manually. We recommend that you file electronically rather than online rather than manually.
Sheikh from YouTube wants to know if you can file a transfer of an H-1B if you don't have pay stubs yet. In his situation, he finally got the approval of an H-1B that was filed last year, but has not joined that company yet. So I'm assuming this was approved as a change of status, which means from the date of approval going forward, you're now in H-1B status, but if you're not working for that employer, you're not maintaining that status. That means you need to file a transfer within 60 days of that approval notice date in order to take advantage of the grace period. And in that situation, you would need to document that up until the date of the H-1B approval, you are maintaining your prior status, whatever that was. And then from the date of H-1B approval going forward, you're using your 60-day grace period.
Nandita is asking this question. If a person has filed a change of status application, are they doing the biometrics? They started doing biometrics right now. They haven't caught up. Previously, the biometrics were getting done within probably a month period, at the most about 45 days from the time you file the change of status application. But now, because of the COVID, they've been backlogged, but they're starting doing the biometrics at this point of time.
Selfmade from YouTube wants to know what's going on with H-1B receipt notices for the CAP that were filed in June. So I updated my statistics on immigrationgirl.com yesterday with the latest. As of right now, I think it's still close to about 50% of the applications in our office are not received a receipt notice yet.
This, you mean to say the ones that you filed in June, Emily?
Yes.
Man, that's a lot of tension for the people.
Yeah.
What about the people who did they got their checks cashed?
That's a good question. I have not
recently checked on it.
looked into that yet.
Okay.
Because I think it's a little early, since it seems to be kind of across the board. A lot of people don't have the receipts. It doesn't seem like anything's out of the ordinary. But if you're needing that receipt number to do a premium processing upgrade, you can check to see if the filing fee check has been cashed and get the number off the back. Same if you need that receipt number for your automatic cap gap extension I-20, you can try to see if that check has been cashed.
George has this question. He's planning to file a change of employer from now, and his I-94 with his current employer is expiring in March of 2021. Is it advisable to go for normal processing? No, George, I would not advise you to go for normal processing. I would recommend that you go for premium processing. One reason, some of the reasons that I will explain is that don't take chances. The second one is that we don't know about the USCIS furlough. We don't know if the premium processing is going to be cancelled at a later point of time. For all these things, it's better to get a result way earlier before your I-94 with your current employer expires, because there will be much better options that you will have if the I-94 is not expired.
Abyssography from YouTube wants to know what will happen to approved I-140s when merit-based immigration comes in place. So first, let me address merit-based immigration. So when the Trump administration came in, the idea of merit-based immigration was really brought to life in the RAISE Act, which was a bill that was entered into to basically change how we give out green cards, change how we give out H-1Bs, and make it a more merit-based point system. As you probably know, that bill went nowhere fast. The negotiations fizzled out before they even started. That is a different type of merit-based immigration than what the Trump administration is talking about now. So when he was talking about merit-based immigration, an executive order and a bill a few weeks ago, completely different than what they were talking about with the RAISE Act. What he means now by merit-based immigration is no TPS, no DACA, eliminating the H-4 EAD, getting rid of the diversity visa lottery, eliminating what he calls chain migration, and eliminating all of that. That's what he means by merit-based immigration. I don't see any likelihood of change to the employment-based visa system under the current administration. So let me start by saying that. If we were ever to have a law passed by Congress that changes to more of a point-based system, that law will include a transition process, and so we will know how that works when it actually happens. It will be a law that takes effect in the future after this transition period. So for those that already have an approved I-140, I would spend very little time worrying about what will happen when merit-based immigration comes, because number one, it's probably not going to come like you think it is, and number two, the plan itself would address what happens to people who are already in the old plan.
Question from Prakash Reddy is asking the question, my H-1B has been approved in consular processing. Can I now change to the change of status, the application which is already approved? Yes, with the same company you can. However, we need to look into if by any chance you were on the day one CPT, you may want to evaluate your chances. Is it worth for you to go for change of status, or maybe just stay on the consular processing, and when the consulate opens, you can go and get the stamping at that point of time. Rani from YouTube has this question. She got an RFE and they have issued a notice of intent to deny. Will that be considered in the normal processing when she responds to the notice of intent to deny, or will it be a premium processing? If you've already filed in the premium processing, they will consider, once you respond to the NOID, they will consider it to be in a premium processing. It will not be considered in the normal processing. Pradeepta has a question from YouTube. How many months it will take to get an N400 approval if you have filed in 2020? It may take anywhere between I would give an estimate between 12 months to 24 months. depending on which district you are located at. The N400s require that you need to be interviewed, and the backlog depends sometimes upon the jurisdiction in which you are located at. Some districts are very good, some districts are very bad. Normally, the smaller districts are much better in getting these things approved. Just for example, I'll tell you, San Antonio is a smaller district as compared to Dallas or Houston. So San Antonio has much faster chances. But it varies depending on each particular district though. I would say anywhere between 12 months to 24 months is the time.
Bhavya from YouTube wants to know if we can go to Mexico to extend the I-94 due to a passport renewal. So the short answer is maybe. So I'm assuming that you're referring to automatic revalidation, where you have an approved I-797 with an I-94 that's attached to that, and maybe the last time you entered, your passport was expiring, so you got an I-94 that was for a shorter validity period, and now you have the renewed passport. So yes, automatic revalidation is still possible even with the current executive orders in place. However, remember that we still are under an essential travel restriction. So if you are traveling to Canada, Mexico, between Canada, Mexico, and the United States at the land ports of entry, they are only allowing essential travel. And visitors for pleasure or tourism is not allowed. So if you're going to go that option, you would have to fly to Canada or Mexico and fly back in order to get the new I-94.
Arnab from Facebook has this question: would they cancel the H4 and the H4 EAD because now they are not doing biometrics? No, they can't just cancel the H4 and EAD. Arnab, there is a good chance, of course, the things will get delayed, but no chance that they'll just cancel it for the purpose they can't get the biometrics. Maharshi from Facebook has this question: can we apply premium processing for the I-140? The answer is yes. The employer can apply I-140 in premium processing. I strongly suggest that anybody who's filing an I-140, if the premium processing is available, go for it.
Mohammed from YouTube had the I-485 approved recently, but the card still hasn't come in the mail yet, and the current EAD based on that pending green card is expiring next month. He wants to know what happens at that point if he doesn't have the green card yet. So the I-485 approval means you are a permanent resident and should be lawfully in the country and allowed to work, but you don't have the document to prove it. So right now your best option would be to call customer service, request an InfoPass appointment to get the green card stamped in your passport so that you can use that to show your employer for your I-9 purposes when they update that. There is a lawsuit that has been filed on behalf of EAD and green card people who have already been approved but have not received the card. That lawsuit's pending. I believe there's a hearing on it in the next few days for a preliminary injunction. So that may help to speed things along.
Arzu has this question. I would call it as a question of the day from Facebook, and he's asking the question: he's filing a concurrent H-1B with the second employer. Does he have to share the information with the primary H-1B sponsor? As far as the immigration is concerned, though, you are under no obligation to share with the primary H-1B employer that you're concurrently filing another H-1B with a different company. Under immigration law, you are under no obligation to share that information with your primary employer.
Nitin wants to know if USCIS is still conducting site visits for H-1Bs. Yes, they do. The FDNS fraud detection security process is still going on. However, I've not seen during the COVID-19 situation, they may not be in-person site visits. Most of the time, employers are receiving an email from an officer asking a random bunch of questions, and the employer has to respond to that, and that is the site visit. But they are still going on, just not in person.
Praneeth has this question: can I work on the EAD application receipt notice? Praneeth, if it's an H4 EAD or L2 EAD, and based on the extension of the EAD application, you cannot work. However, though, if it's an adjustment of status EAD, that means that you file the 485, are also called as adjustment of status. And this EAD is an extension for the existing EAD application. You are allowed to work up to 180 days. One more time, H4 EAD extension people cannot work once the EAD extension the time is over. But the adjustment of status EAD extension people can work up to a period of 180 days. Also, if it's a STEM extension, that is after you get an OPT, you get a STEM extension. If you file the STEM extension at the proper timing, you can work up to 180 days, even though your OPT has already expired.
Ronnie from YouTube wants to know, if a change of status is denied, how many days can you legally stay in the United States? So it depends on whether you're still maintaining your previous status and whether that I-94 has expired. If you're still maintaining your previous status, you can continue to maintain that status as long as it's valid, meaning until your I-94 expires. However, if your I-94 has already expired and you're no longer maintaining the prior status, the denial puts you out of status and you're immediately accruing unlawful presence. That means you are not legally present in the U.S. and there are 0 days that you should remain in the U.S. unlawfully present.
Deveshu Nigam has this question. His I-140 has been approved and he's in the 5th year of H-1B. If he wants to extend the H-1B with the different, if he wants to move to a different employer, does the new employer need to file an I-140 application? They want you, if your I-140 has been approved and it's been approved for more than 180 days, and it's not been withdrawn as of today. Now, it's been approved for more than 180 days and it's not been withdrawn. You can move to a different company, second company. The second company do not have to file an I-140 application for you to extend the H-1B. So you can join the new company. You can even extend the H-1B with the new company using the old company A's I-140 approval. You can move from company B, that is the transferred company. You can move to a third company also using the I-140 approval of the first company, if the I-140 has been approved and approved for more than 180 days. I'm assuming that you're an Indian national and your priority date is backlogged.
Vera from YouTube was previously on H4 with the valid H4 EAD and switched to H1B and now wants to switch back to H4 and wants to know if that EAD can still be used because it still has another 2 years left on it. So let me start by saying there is no guidance from USCIS on this specific issue. When I looked into it previously, my original thought was no, that EAD is not valid anymore because you're no longer in H1 status. But after looking into the laws and the regulations about EAD validity, I think it is still valid. The rule is that an EAD remains valid until it expires or is revoked. Just because you moved to H1 status, USCIS has not gone back and revoked that EAD, so it is still valid. Now you can only use it if you're in H4 status. You can't use it when you're in H1 status, for example, but I don't think you need to file it again.
Sandeep has this question. His H-1B has been revoked because of multiple H-1B filings last year. Can he now move to F1 visa by joining another college without going outside the country? Once your H-1B has been approved, that you said which was approved last year, you have moved into the H-1B and your F-1 is no longer valid. So since your H-1B has been revoked, you are not in lawful status. Once you're not in lawful status, you cannot change the status to F1 visa. So you have to leave the country, and I would strongly recommend, Sandeep, that you consult an immigration lawyer because you are accumulating the unlawful presence, and you may have already done some mistakes by working with companies that have filed multiple H-1B applications. So that's a wrong thing that you need to consult for an immigration lawyer too.
Nitin from YouTube wants to know if he applies for an H-1B petition with a second employer for concurrent employment, does he have to wait until it's approved before he can start working? No, you can actually, it's kind of treated like a transfer to where you can start working for the second employer once the application is properly filed with USCIS.
Good question is coming from Ahmed Azar from Facebook. Can we file an adjustment of status using the filing dates, or do we have to go with the final action dates? Ahmed, each month it changes to file the adjustment of status. There is a Department of State that issues the final action dates and the filing dates. But the USCIS, which accepts the adjustment of status, will tell whether or not they are going to use the final action dates or are they going to use the filing dates. For the month of August though, Ahmed, it is going to be the final action dates, not the filing final action dates, not the filing dates. So each month it will differ. For the month of July and August, it is the final action date. What will be for September? I cannot tell right now. I can tell it on August 20, somewhere between August 20th and 25th, I can tell at that point of time. So when you go to the visa bulletin application though, there is another link there that goes to the USCIS link. You click on that link, that you go to that and you go to that particular month, whether it's July or August. In the case in September, you can go in there and check it out. Are they using the final action dates? Are they using the filing dates? It will keep changing every month. There are sometimes they use the final action date, sometimes they use the filing date. So every month it changes. So you have to check every month very closely. Whenever you see that you have the question that you are coming into the filing dates, I still will like to check with my lawyer. Hey, what's going on, lawyer? Can we file it? Because don't take into account, maybe sometimes you may misread it. There's nothing wrong in asking your lawyer, can I file the adjustment of status? Because it says that I can do it based on the filing dates. Let your lawyer tell no or yes at that point of time to you.
Anandaraj from YouTube wants to know how companies should be handling the notice of filing for perm when the offices are all closed and everyone is working remotely. So we've discussed this before, that the Department of Labor basically came out and said the company still has to comply with the hard copy notice of filing posting requirement. And then they came out and said we're not going to give any other guidance on that. So the company still has to post the notice. What we were talking about is making sure that workers can actually see the notice. However, as part of the American Immigration Lawyers Association virtual conference that happened last week, Department of Labor officials were there, and they basically said that all you have to do is post it, just like you would normally post it. Whether workers are there or not to see it is not part of the equation. If the office is like the building's completely closed, you could even post it on the front door of the building, and that would be sufficient for their needs. So it looks like it's not really that big of an issue compared to what people were worried it was going to be.
Mangesh has this question: how long can a person stay with an approved H-1B 797 without a job? I'm assuming that you have a valid I-94, Mangesh. The time limit that you have is 60 days. If you don't have a job, that is the grace period that's allowed. More than 60 days, you cannot. If you can't leave the country, you can't get a job, because of the pandemic situation right now, I may suggest that you file a B2 application, and that too before the 60 days, so that it can allow you to transit out of the country. It may not allow you to come back into H-1B, but it will give you some time for you to leave the country.
Kedar from YouTube has already finished 6 years in H-1B status, has an approved I-140 from a previous employer, but does not have the approved I-140 from the current employer, and wants to know if he can still extend the H-1B even though he doesn't have the new I-140 approval. So assuming that the old I-140 from the previous employer was not withdrawn before January 17, 2017, and you you were there for at least 180 days after it was approved, you can continue to use the old employer's I-140 approval notice to get H-1B extensions with any employer, regardless of whether you have a new I-140 approval notice or not. You can keep doing that all the way up until your priority date is actually current.
Shilpa from Facebook has this question. What will happen to the H-4 EAD when the H-1B person switches a job? I'm assuming that the H-4 EAD validity is still there, Shilpa. And if the H-4 EAD validity is still there, you can continue working on the H-4 EAD even though your spouse has switched from one company to another company. So you can continue working. There are also a lot of people ask the question, my EAD is expiring 1 year down the line, H-4 EAD. Can I file an extension of the EAD along with my spouse's H-1B application? There is a rule that says that you can only file within a certain time, but I have not seen a single EAD getting rejected. I strongly suggest that please file H-4 EADs as early as possible. And if your spouse is filing a H-1B transfer of application or extension application, just throw in the H-4 and H-4 EAD at the same time, because H-4 and EAD are taking a long time. The more earlier that you're going to file, the better it is. If you file more than 180 days before, is there a chance? If you file more than 180 days before, that means that if it's expiring, let's say in 180 days, let's say in March of 2021, can you file the extension right now? There is a very slight chance that they will deny it, but we have not seen any denials of such nature at this point of time. So I strongly recommend people, even if it's March of 2021, keep filing the extensions of the H-4 EAD. If by any chance the immigration changes its stance saying that, hey, you filed too early, I'm going to reject it, that's okay. You can refile your EAD later on. So strongly recommend to file as early as possible.
Sandeep from YouTube wants to know if a spouse who has an H-4 with EAD is eligible for unemployment benefits, and if so, is that going to be a negative impact on the green card application? So an H-4 EAD is generally an unrestricted employment authorization. It allows the H-4 spouse to work for any company, anywhere. So that means that in most states they should be eligible for unemployment benefits, assuming that they were working and meet all of those requirements and then lost the job. If they receive unemployment benefits, there's no impact on the green card application. Unemployment benefits are basically more like insurance. You and your employer pay into the unemployment insurance program every time you get a paycheck, and so you are just using your insurance benefits. It's not a public benefit that's part of the public charge rule for your 485.
Mahesh Shankar has this question, can I upgrade from EB2 to EB1? If one of the, because I'm on the senior manager level, I manage a lot of people who have degrees. That by itself does not qualify for you to EB1. For you to qualify for EB1, there are 3 different criteria: extraordinary ability, outstanding researcher, and multinational executive manager. This multinational executive manager requires that you must have worked for outside the country for more than 1 year for the same company before you came into this country. I would strongly recommend that if you feel that you qualify for any of those things, 3 things though, I would recommend that you consult a lawyer. Most of the time, the answer that comes from us is no, but very rarely some things come out yes to convert into EB1. EB1 is not an easy piece of cake. If somebody asks me, can I convert from EB3 to EB2? Yeah, that's mostly we do. That's not a problem. Can somebody downgrade from EB2 to EB3? That's an easy task to be done. But upgrading to EB1 is not an easy task. It depends on a lot of different variations, and not many people will qualify for EB1.
Arpit from YouTube wants to know about the new prevailing wages that took effect on July 1st and how they impact cases that might be in progress or those that are already approved. So yes, prevailing wages are updated every year on July 1st. So for any LCAs submitted on or after July 1st, we have to use the new data. If the LCA was already submitted before July 1st with the old data still applies to your case. That LCA remains valid for the entire 3-year period it was requested, and that old prevailing wage still applies to your case. So the fact that new prevailing wages came out has zero impact on your case when your LCA is already certified with the old wages. Prakash from YouTube wants to know his H-1B was approved in consular processing. I'm assuming that was this year's H-1B cap subject petition, but wants to know if instead he can apply for a change of status because obviously consular processing, there's a lot of uncertainty with consulates not opening and with travel bans and all of that. So in general, if the same employer is sponsoring you, that employer that got the approval in consular processing is eligible to file a petition again. It is not subject to the cap at this point, and this time request a change of status. Now first, you have to be maintaining your current status, and you have to understand that the new petition is treated as if they've never filed before, so everything is going to be adjudicated all over again. So just because you got approved the first time around doesn't necessarily mean you will be approved the second time around. There's no guarantees. And the issue with the status, you definitely need to discuss with the attorney to understand whether you're eligible for a change of status. For example, if the reason you filed for change of the consular processing is because you're on L1 and you wanted to delay the effective start date of your H1, but now you've changed your mind, that's fine to do a change of status as long as you're maintaining your L1 status through September 30th. That being said, is not the same for someone who's in a day one CPT program for F1, where we advise that a change of status is likely to be denied and put you out of status. So in that situation, we don't recommend going that option.
Hari has this question. His friend got stuck in India because of some family emergency. He has a H-1B visa stamping. How long can he stay in India? Will it and continue working in India? Harin, the person can stay for a long period of time in India and continue working for the company because he's in India, he comes under India jurisdiction. However though, when he comes back to US, I want him to be very careful. He needs to show that he's been working for the company. He needs to show that he still has the job. He still needs to have his manager or somebody to be available just in case the immigration officer wants to call the employer to make sure he has employed. We are noticing a lot of problems with the people who are entering into the United States, and the CBP is doubting, that's a Custom and Border Protection people, they're doubting if the job still exists. Hey, you've been out for 6 months, do you still have a job? They're doubting if the job still exists though. So I want this person to be well prepared to go when he comes into the United States to answer the questions for the CBP. Look, I've been doing this job, everything is doing fine. Here are my things that shows that I've been working with the company, even though I'm in India, and any paychecks that you've been getting, show them. At the same time, I want to have a fresh dated letter from the company to keep it with him and have the manager available just in case if the CBP wants to call the manager of the company.
Raj from YouTube wants to know how long it's taking for a Freedom of Information Act request or a FOIA request. So I would say anywhere from probably 8 weeks of 6 months to 8 months, somewhere in that range. It's not
Even
a super
6
fast.
to 8 weeks.
No, up to 8 months,
Okay.
I would say. It's not a super fast process, but it is a good way that you can obtain a copy of your immigration file. It's helpful if your employer is not sharing your I-140 approval notice. You can do a Freedom of Information Act request online. It's a quite simple process.
Arun wants his reading capacity tested. From Facebook, he's telling that he read the August 2020 Visa Bulletin, EB1 India, and they are telling it to use the final action final action, not the filing chart. Is that a correct reading? Yes, Arun, you read it very right. Believe me, guys, it's not that easy to read those things, to tell when it is. When I train any of the new legal assistants that come into our office, when I train them, they get very confused in those things. And I understand, Arun, why you want to test yourself. That is very good. You read it very right. For the August EB1 India, it is the final action chart, not the filing chart for the August. One question from Bhattacha G is that I have a 797 approval. I'm assuming that it is for H1B, yeah. And he's telling, can I go out for stamping? Emily, what do you say? Because of the Trump executive order, he cannot go, is the first initially, and then they said H4s can go. Now they're telling if the person is in the United States, they can go. The question is, can they? I mean, because of the tweet, or executive order says no, tweet says yes. What do you say?
I say right now, if you can, yeah, that's the difficulty. I think that they're making it so vague and unclear just to create chaos and to have fewer people apply for their visas. I don't think we have a specific answer yet.
We will come to know as the people will go and get the stamping, because the consulates are only giving emergency appointments right now. We don't have enough data to tell you this way or the other at this point of time. The executive order, then the change of the executive order, then the tweet from the request to the State Department, and the tweet from the State Department. It is really confusing right now whether or not you can go and get the stamping. I mean, at this point of time, I would recommend, even if you get an emergency appointment, don't go. I would recommend to wait until we get a little bit more clear data, and please come tuning to the Facebook and YouTube every week. We'll update you as the things progress. Don't forget that if you want to make an appointment with me or Emily at any point of time, you can make an appointment at rnlawgroup.com. Also subscribe to the blog of Emily, which is immigrationgirl.com. She updates any recent fresh news that comes out of the immigration, or whatever the business migrant need. She updates it very frequently. When is our webinar, Emily?
Yes, we are having a webinar tomorrow. I believe it's at 2 o'clock Central Time. If you go to rnlawgroup.com and click on our news section, you can get the link to sign up for that. You do have to register for the webinar in advance, but that's happening tomorrow, and it's going over what to expect for immigration in the coming 6, 8, 12, 18 months, what might happen in the election that might change things for immigration, specifically for employment-based. So it should be a good presentation tomorrow afternoon if you're able to join that.
Emily, with regards to the H4 EAD, because now Trump administration is trying to just take off everything. Now DACA, he's trying to take off DACA too, which Supreme Court gave a judgment in favor of them. Now he's saying no extensions. Maybe he was going to issue another executive order banning the DACA. People are fearful on the H4 EAD. What are you trying to do for them? I mean, is there anything you can do for them if the Trump administration comes and bars the H4 EADs?
Yeah, so we are expecting a new regulation to be proposed that would eliminate the H4 EAD. We're laying the groundwork right now to fight that. We have actually started a nonprofit organization called Save H4 EAD, and we are our goal with that is to start conducting surveys, writing reports to basically explain to the administration why we need the H4 EAD, why they should not eliminate it, why it does not negatively impact U.S. workers, and how it would harm businesses if they eliminate it. And so if we have that data as a backup, when the Trump administration comes out with that proposed rulemaking, there's a notice and comment period, meaning we will generally have 60 days to submit our comments as to why they should continue with the H-4 EAD, and we'll be well positioned to submit our comments. We'll be able to provide sample comments with the data to back it up for you to submit as well. Then if the Trump administration moves forward and still eliminates it, our next step would be to be prepared for litigation. So that's what we're planning with Save H-4 EAD. So we have a website coming soon on that, but you can follow me on Twitter at Immigration Girl to see my latest tweets about Save H-4 EAD and how you can help.
Anything else, Emily?
I think that's about it for today.
Thank you guys for coming in. The next YouTube and Facebook Live will be next week, Tuesday. Every Tuesday at 5 p.m. Central Time, we do bring in immigration updates. Thank you for tuning in.